Number 13, the people of the state of New York versus Omar Alvarez. Thank you, sir. Good afternoon, sir.
Good afternoon. Your Honor, Richard Greenberg for Omar Alvarez. May I reserve 3 minutes for rebuttal?
Sir?
Yes.
Yes,
3
you
minutes.
may.
Thank you. Your Honors, Omar Alvarez was sentenced to consecutive terms totaling 66 and two-thirds years to life. I'm sorry?
We're familiar with the record, but are you advocating that the failure to brief the excessive sentence point is a single egregious error that warrants quorum nobis relief?
In this case, it is. But in this case, also, I asked the court to look at the totality of circumstances and the totality of counsel's performance to determine whether Mr. Alvarez received meaningful representation.
Back to the first part of Judge Feynman's question. If failure to raise the excessive sentence point is ineffective, and you said in this case, what would the rule be? Why this case and not a case where there's a 5-year sentence?
Well, every case has to be determined on its totality of circumstances and the performance by counsel.
What's the totality? But
in this case,
again, to go back to just the excessive sentence point, and I think your answer to Judge Feynman's question was, yes, failure to raise the excessive sentence point standing alone in this case, was ineffective.
When I say standing alone, I should back up and say coupled with the fact that counsel never communicated at all with Mr. Alvarez. He never explained to him that he had a right to that, that kind of argument.
To support that point, you have the affidavit of your client and the one letter, but we'll never really know what was in Mr. Franklin's file, or Mr. Brown's file, rather, because obviously he's deceased and those files are long gone.
We have a much broader record than that, Judge Feynman. What we have here is not only my client's affidavit, but his wife's affidavit. And what we know, and is undisputed, is that my client was in the dark about his appeal for years. And in fact, when Diana Alvarez contacted him in 2004 and said, "What happened to your case, Omar?" he said, "I don't know. Can you contact my lawyer and find out?"
Well, but doesn't that all also relate to what arguments were made and what other arguments might have been made? Now, of course, none of us would minimize the importance of communication between an attorney and a client. But when we are reviewing quorum nobis application, okay, we consider a number of things, one of which is how might things have turned out better if something had been done differently. So looking at the communication piece, to me that ties in with if counsel had communicated with his client that maybe there was something that he might have argued that he didn't, or he might have argued better. And I see nothing in this record that suggests that there were other arguments, again, aside from the harsh and excessive, that could or should have been made, or that the appellate division didn't fully consider the arguments that were made.
Judge Stein, I think it's very, very important for this court to look at the nature of an excessive sentence point in general and look at it in this case.
Well, now, before you talk about excessive sentence, I think we were talking about the lack of communication and the other pieces, because...
Right, and I'm going to tie that together.
Okay.
The fact is that an individual like Mr. Alvarez, who's convicted, has an absolute right to appeal not only his conviction, but he has an absolute right to have the appellate division review the sentence and reduce that sentence in the interest of justice if the appellate division finds it unduly harsh.
But the only time we've ever held that counsel, as far as I know, that counsel was ineffective for failing to raise a single argument is when it would have been clear and dispositive.
Right, and that would be...
positive. And how could that be here?
Right, and clearly it's not, and yet in this court's decision in People against Gonzalez back in 1979, you granted a reversal and you sent the case back for a new appeal.
Wasn't Gonzalez...
Where there was no dispositive issue.
Mr. Greenberg, wasn't Gonzalez a little different? I thought there he just listed the points. There were no arguments at all.
Correct, there was a little difference, but let me get back to the excessive sentence point of this, because Mr. Alvarez essentially got life without parole, 66 2/3 to life. He could have gotten as low as 15 to life, which would have been 50 years, more than 50 years less than he had. The difference is really incredibly important, because
Well, can we
the difference is
consider-
whether
on
he
that-
have
on
a
that
chance.
point, can we consider things that happened after his sentencing and appeal?
Sure,
terms
it's in
of-
this record.
But
It's part of the quorum nobis record.
aren't we reviewing whether he was denied effective assistance at the time of his appeal?
Your Honor, at the time of his
Whether
appeal...
he received meaningful representation?
Correct.
How
And-
could counsel at that time have known what he would or wouldn't have done years later?
He wouldn't, nor would the sentencing court or the appellate division. That's the whole point. You have a 19-year-old who had no prior record, who was convicted clearly of very serious crimes, but could have gotten 15 to life, which would enable him to go to the parole board someday and have parole consideration.
Theoretically, yes, but if you
Not
read
theoretically.
if you read the record, what happened at the sentencing was pretty egregious, and it's hard to imagine that based on what the sentencing court knew at that time and what the appellate division knew at the time of the appeal, that that he would have been likely to get 15 years to life.
I'm not saying he would have been likely to get 15, but he could have gotten anything between 15 and 66 2/3. And the difference is, if he had gotten a lower sentence, he would be eligible for parole, he would go before the parole board,
Counsel,
he
we
might come home
understand that.
someday.
Counsel, we understand that. But
Well, it's an important point, Judge.
It is, and we understand it. But one of the problems I think we're having is not everyone raises excessive sentence claims on appeal, right?
Correct.
And they're not ineffective, we would say.
Not in every case, no.
Right. So there are strategic reasons not to raise them. Perhaps because the client was laughing and doing things at the sentencing that the trial judge, just hypothetically, found very offensive.
Judge.
But going back, can I speak? Going back to Judge Feinman's point, we don't know now whether there were strategic reasons, and we'll never know, for this particular lawyer not to raise an excessive sentence in this case because he's died. And does that go to a due diligence requirement on the part of the client here, your client, to raise this at some reasonable point of time when the client realizes...
He tried to. He raised it as soon as he found out that his appeal had been denied, that his conviction was affirmed. He filed a motion in the appellate division to have counsel appointed to file a quorum nobis. That was denied. He then filed a 440 motion.
Did he raise the
and he
excessive sentence issue in the initial...
No, he
quorum
didn't
notice?
know that he was even entitled to excessive sentence, Your Honor. That's the whole point of communication. My client, and just to get to the point of strategic reason, it is inconceivable, and I've practiced for over 40 years, it is inconceivable that any competent attorney would fail to at least discuss with his client, and if not raise, excessive sentence, regardless of the fact that he may have been immature and laughed at sentencing.
Say then that the co-defendants' lawyers were also ineffective?
We don't know the circumstances of their
because,
case.
They didn't bring
Right.
the challenge either.
One of those co-defendants
Got
committed
100 to
three
life, and one got 66 2/3.
One committed 3 execution-style murders. The other one actually did raise excessive sentence in an initial brief. That brief was withdrawn and refiled without it. We don't know the circumstances. It would be wrong to speculate. My point is that if Mr. Alvarez's attorney had said to him, by the way, you have an absolute right to ask the appellate division to consider reducing your sentence for any reason that it seems, it feels appropriate, would you like me to do that? It is inconceivable that Mr. Alvarez would say, no, that's okay because I laughed at sentencing. The whole point of...
No, wait. It wasn't just laughed at sentencing. There was a lot more. It was the nature of the crime. There was a failure to take any responsibility. There's a lot that happened at the sentencing. But that aside, you're saying that a competent attorney could not possibly have weighed the danger to his client of bringing all of this up and you know, in the appellate division's face, rather than focusing on what he thought were errors at trial that went to the fairness of the trial itself and that could possibly result in a reversal. How could that not be a
Not in this
reasonable,
case.
even if unsuccessful strategy?
Not in this case. Point 1 of the brief, the first point that counsel raised was a suppression issue that would have had no effect on the conviction or the sentence here. Would have done no good for Mr. Alvarez. What Mr. Alvarez wanted was a chance to come home someday and get his case before the parole board.
Well, what if
And
he
the
got
fact
a new
that it was
trial? What if he got a new trial because of these other points raised?
he wasn't going to get a new trial. Those points were frivolous. They were blown out of the water by the DA and by the court. What he needed
Counsel,
was...
let me ask you this, now
Yes.
that you've said that. From the vantage point and with the benefit of People v. Gonzalez, are you in part arguing that given the little we've said about ineffective assistance of counsel when it comes to appellate counsel, that the rule needs to be tweaked? Is there something else that needs to be the consideration and the focus of the bench when it's thinking about appellate counsel's effectiveness that's different from trial counsel's effectiveness?
I think it's critical that counsel communicate with his client. And I object to any characterization that says that, oh, this is all based on my client's self-serving affidavit. The record is clear. He didn't even know what happened in his appeal. He never saw a copy of the brief. Had he had that information, he wouldn't have sent his wife looking for that information. He didn't know anything. His lawyer never contacted him, never told him, you can ask the appellate division to reduce your sentence so that you might someday go before the parole board. Judge Stein, I certainly agree that the crimes are very serious crimes. My client's behavior was reprehensible. He did not take responsibility at the time. He laughed. He was not acting appropriately. He was a 19-year-old. He was a teenager. The whole point of getting a sentence that has a minimum where you can go to the parole board someday is to allow time for growth and reflection and rehabilitation and remorse and for someone to take responsibility as he does now.
So is that what you're suggesting might make this different from what otherwise sounds like a rule that means every appellate counsel must raise an request,
sentence?
thank you, a request for reduction of sentence
No.
because it's excessive unless their client says otherwise?
No, I'm not even asking for that. I could give you plenty of examples of a strategic basis. Let's take a defendant who has a prior robbery conviction. He's now convicted of 3 armed robberies. The minimum sentence on each one is 10 years. The maximum is 25 years, right? Let's say the judge says, okay, I'm giving you 12 years on each of these 3, but I'm running them concurrently. So instead of the possibility of 75 years, which he could have got, he's getting 12 years, just 2 years above the absolute minimum he could get. I could understand in a case like that a lawyer saying to his client, you know what, if we try to argue that your sentence should be reduced, we are going to upset the appellate division. They're going to look at us in a way, they're going to think, what the heck are you doing? Let's focus on these other issues that we have. However, the client may say, you know what, those 2 years are important to me, I want you to raise it. That would be something that the lawyer would explain, and the client would have a right to raise on his own if he wanted to. He has to know he has that right.
If we agree with you, and I think what I'm hearing you say is that when they receive the absolute maximum, right, then there's no reason not to raise it, right? Then is every defendant who is serving time now, whose appellate counsel did not argue that, who received the maximum sentence, is every one of those
No.
people entitled to now
No,
bring
no.
an error quorum
No,
notice?
of course not, Your
Why
Honor.
not?
Because there are a lot of factors. It's not just getting the maximum. It's a question of what was the minimum, what was the spread. Here, the spread was over 50 years. The spread for Mr. Alvarez was the difference between having a shot at parole someday or dying in prison.
Does the nature of the crime matter?
I'm sorry.
In addition, if I may,
Why don't you let...
The problem that I'm having is what is the rule that is going to get articulated?
okay, the rule is very simple, Your Honors. I am not asking for any new rule. The rule that this court has maintained for 40 years is that in New York, unlike in the federal courts, unlike Strickland, The New York rule for ineffective assistance of counsel is that counsel must provide meaningful representation. And if the case is going to rise or fall on whether we could have won the excessive sentence, whether we could show that we would have gotten a better result in the end, obviously that is going to undo that standard of meaningful representation. I just want to say one more thing. I know the red light is on, but, Your Honors, an excessive sentence point is absolutely qualitatively different from every other appellate argument. You can raise it in every single case. There's no preservation requirement. There's no harmless error. There's no error requirement, in fact. It's not a question of whether the sentencing judge made a mistake, broke the law, or abused her discretion. It's a question of whether the appellate division thinks that a lesser sentence would be more humane, more appropriate in the case. And so it's really a qualitatively different thing. The appellate division in the First Department reduces sentences about twice as frequently as it reverses convictions. You have a better chance of getting a sentence reduction on appeal than you have of any other kind of relief.
It partially depends on what years you look at.
Well, I just checked the other night, Judge Feinman, between 1995 and 2005, that 10-year period, the appellate division First Department granted more than 200 discretionary sentence reductions. That's over 20 a year. And that's very significant, because what Mr. Alvarez lost here was the opportunity to have the one thing that he needed, a second bite of the apple, some other court to review that sentence and say, you know what, that's life without parole is too much for this case. You need to have a shot, whether it's 15 to life, 20, 25, 30 to life, something where someday down the road you can go to the parole board and explain why you have a right to go home.
Thank you, Mr. Greenberg.
Thank you so much.
Counsel?
Good afternoon, Your Honors. Jan Savitsky for the people.
So, I mean, you concede, if I recall correctly, that the brief that was actually filed had significant problems with it. And I guess putting aside the whole issue of excessive sentence, how does this brief that was filed satisfy the Stultz standard?
Absolutely, Your Honor. The brief that appellate counsel raised 4 issues for appellate review. The suppression issue, an issue that the judge erred in denying an adjournment, a challenge to the judge's protective order, and a challenge to the weight of the evidence with respect to the conspiracy charge. Those 4 issues were presented in a manner that was sufficient for appellate review. And we know that because the appellate division addressed each of those claims. And in fact, it was only appellate...
You mean as long as you raise the issue, regardless of the quality of the advocacy, regardless of whether or not you fail to cite appropriate case law, that's good enough? That's the benchmark?
That's not what I'm saying, Your Honor. If, as counsel characterized it just now, these claims were purely frivolous, then the thorough manner in which the people responded to those claims and the detail with which the appellate division took to address each of them simply would not have occurred.
Wouldn't you agree that most pro se briefs, and you've seen more than I have, I'm sure, are better than this brief that Mr. Brown submitted?
Your Honor, this brief identified 4 legal issues.
And so do pro se briefs, no?
I have not seen a pro se brief that's better than this brief. But that is also not the standard, Your Honor, because the reason we know beyond the quality of this brief is that Mr. Greenberg, after spending months combing this record, the only issue that he could identify that counsel could have raised, which he didn't, was an excessive sentence claim that absolutely had no chance of success. What Mr. Greenberg's search over the last few days on Westlaw did not find was a case in a homicide of an innocent teenager with 2 other teenagers'
But
names.
I understood his argument to be, that he's focused on this excessive sentence, and the reality is that I now better understand his argument, which is it meant there was no possibility of ever getting out, and that's what it turns on. Okay, but he's also raised what he says are other deficiencies of counsel. They're saying we have to look at all of them. And again, from the vantage point and with the benefit of People v. Gonzalez, why isn't he right that it's the major deficiencies in the brief, it's the failure to communicate with the client, it's not acting expeditiously or in any timely fashion, at least until you hear otherwise, to perfect the appeal, to file papers, and that's just some of it. Why isn't that, when you step back and say, this is not what the Court of Appeals should say is good enough for indigent defendants?
Well, if Your Honor puts aside the excessive sentence claim, then all of the other claims that Mr. Greenberg raises, which I would love to have an opportunity to address, and in particular the communication claim, all go to the first prong of the Stultz test. Did counsel's appellate advocacy fall below an objective standard of reasonableness? Even if you grant that some of those errors may have dropped below that standard, which we cannot, as some of your honors have alluded to, because we have no idea whether the communication allegations are true. Then
I thought counsel admitted that he hadn't talked to his client. When he finally hears from the client, he
Your
says,
Honor,
what's happening?
Your Honor, I think what you're alluding to was in 1999, the case was placed on the dismissal calendar.
Yes.
Which prompted defendant
Yes,
to write
and isn't that the problem? It's on the dismissal calendar. This attorney hadn't done
Your
anything.
Honor, as Mr. Greenberg could tell you, cases end up on the dismissal calendar all the time in appellate courts. But what counsel...
And if that was the only problem, I might see your way. My difficulty is, as he's already raised, it's not just that one thing, it's several things. And you're right, the people put in a spectacular brief. And you compare that to what his attorney did, it's really troubling.
Your Honors, the co-defendants also presented more polished briefs to the appellate division. And those polished briefs accomplished even less for their clients.
Yeah, but our standard is not that the defendant has to get a reversal. This is not Strickland, that you have to show prejudice. We've been very clear about that.
Your Honors have also been very clear that while prejudice is not a required component of the test, the court is extremely clear in Stultz that they would be skeptical of any claim.
No, we've said we would consider it. It's something to consider because the factor that you're focusing on is, did this individual get meaningful representation? Here's my problem. The question I asked him, we've talked about a fair trial, but of course now we're talking about appellate representation. Is it necessary for us to tweak our rule with respect to the standards applied for ineffective assistance of appellate counsel versus trial counsel?
Your Honor, the rule that exists works. And the reason we know it works is by looking at Gonzalez, which this case is different from in multiple ways. First of all, unlike the lawyer in Gonzalez that simply identified 4-point headings and then said, these points have absolutely no chance of success, a new attorney looked over the record and identified 6 issues that should have been raised.
Now, let me ask you this. Let's say instead of filing the brief, the appellate counsel had submitted this as an Anders Saunders and said, these are the 4 points I looked at, and for all the reasons that the people are then going to later put in response, we can't succeed. But he had failed to mention the excessive sentence. What do you think would have happened when it got to the appellate division?
I'm glad you asked that. The same thing that happened here, Your Honor. The case would, I think that claim would have been dismissed because looking.
You don't think they would have denied the motion and reassigned it because there's that issue that could be raised?
Even in that circumstance, where they were faced with no other issues and wanted to give defendant an opportunity to appeal, even if they allowed an attorney to brief that issue, given the circumstances of this crime, as well as the egregious information that was revealed at sentencing.
But you see, he doesn't have to have a guarantee of success. I think that's Judge Rivera's point and Mr. Greenberg's point, in order to be afforded meaningful representation necessarily.
Absolutely, Your Honor. But when counsel did raise 4 arguments for appellate review and then left out another one that the defendant now claims should have been raised, that changes the inquiry. And you have to look, I mean, I wasn't paraphrasing Stultz, Your Honor. Stultz says we would be skeptical of any claim that does not show prejudice. And if you look at the circumstances of this case, when the appellate division in 2000 reviewing an excessive sentence claim not far removed from the drug and violence epidemic of the 90s, would have looked at the facts of this case, defendant's conduct during sentencing, including the allegations that he set his jail cell on fire and that he threatened to kill witnesses. Additionally, not only do you have the murder, but his torture of women who steal from YTC, including an excessive sentence claim
But
in
isn't
this
that
brief.
part of his point, that those are things that get discussed with the client? About whether or not to move forward when you're talking about a sentence that means no opportunity to ever get out, even though it doesn't say life without parole.
Well, and I think if Your Honor would let me address the communication issue, because I think that goes to that.
Would you just finish? You got interrupted. To include an excessive
Sentence
finish your
claim
thought.
would not only have had no chance of success, but it would have completely allowed the court to not look at any of the other issues that counsel has raised. And in particular, because
Well,
none of
that
the...
might be true in the context of an oral argument if an advocate gets up there and starts saying, you gave my client 66 and 2/3, the judge and the members of the appellate division panel might, get a little steamed or perhaps that's the wrong word, but and so that you would lose focus on those. But in a written decision, aren't they still going to have to answer all the points?
Of course they're going to answer all the points, Your Honor, but I do believe the judges are human, and that had looking at all the information that would have been provided, which wasn't, and nothing that happened at sentencing was included in this brief because an excessive sentence wasn't raised. The judges would certainly have taken note of that, just as Mr. Greenberg would like the judges to take note of all the things that happened in prison to defendant after his acceptance claim was denied.
Counsel,
His
I'm
claim
sorry,
was
you were
denied,
going to
sorry.
go to, I know your light's on, you were going to go to the communication with counsel.
Yeah.
And while doing that, could you also address the due diligence point?
Absolutely. I'll first talk about communication briefly, and then I'll talk about due
Thank you.
diligence. And they go together, actually, because nowhere is the prejudice that the people suffered more evident than in the communication point. Defendant, the only source that we have for the allegation that defendant and his attorney did not communicate are defendants and his wife's allegations. However, not only do we not have the advantage of Mr. Brown refuting those claims, which is what trial counsel did in this case when defendant raised the same exact accusations about communications with his trial attorney, except his trial attorney was alive and filed an affidavit and that motion was denied. But beyond that, there's also reason to doubt defendant's assertions, because two of the claims that appeared in the brief are things that defendant independently pressed. First of all, defendant filed a civil lawsuit in 2000 claiming that the judge should not have ordered the protective order, which was in point 3 of the appellate brief. Second of all, defendant to this day denies being a member of YTC, which was the subject matter of the fourth point raised on appeal. And going quickly to the due diligence element, and counsel may stand up and say it's unpreserved. It's the same exact issue we raised in the appellate division. In a wide swath of this court's cases, including issues such as this one, it has recognized that defendants must act diligently.
But has it recognized that in any context having to do with error coram nobis other than the Cyville situation?
Yes, Your Honor. In D'Alessandro, which was not a Cyville-type case, was a coram nobis case, the court said, and I'm quoting, delay in itself was not enough to deny a coram nobis. What that implicitly leaves room for is delay coupled with a showing of prejudice by the people. And we show that prejudice here not only with the communication element, but also with the fact that we're forced to speculate as to why counsel did not raise an excessive sentence claim. In the brief, counsel even suggested that Mr. Brown did not know that an excessive sentence claim was an option. Luckily, we have evidence from Westlaw cases showing that Mr. Brown did know it was an option and raised it where it was appropriate. But this kind of speculation...
You agree we don't have to speculate about the quality of the briefing, correct?
The brief...
And we don't have to speculate about the fact that this was on the dismissal calendar, correct?
Those two things...
Or about Brown's letter and the content of that letter, correct?
There are certain things in this record. But looking at just those things, along with the fact that counsel raised 4 issues that were preserved, unlike the other co-defendants, which also did not raise ES claims, and that the court decided those claims, and that an experienced and a certainly competent appellate attorney has looked over that record and has identified only one claim that stood absolutely no chance of success at that time, that does not amount to ineffective assistance of appellate counsel, and we urge your honors to affirm defendant's conviction and denial of the quorum
counsel.
notice.
Thank you. Mr. Greenberg?
Judge Leslie Crocker Snyder imposed consecutive sentences totaling 66 2/3 years to life. That is essentially life without parole for a 20-year-old. He would be 87 when he would be first eligible for parole. Life without parole did not even exist as a legal sentence in New York at the time that this sentence was imposed. But yet Judge Snyder took it upon herself to say, you are so bad, you are so terrible, you're the worst of the worst and so unredeemable that I'm sentencing you to die in prison, rather than say, you know what, maybe you'll do well in prison, maybe you'll reform yourself, maybe you'll grow up and mature, and someday you can go before the parole board, which will decide that. Because even in the best of circumstances, Omar Alvarez was going to have a life sentence and was facing the possibility of spending his life in prison. All he was asking for, and all we're asking for now, is a shot at parole someday. With respect to the due diligence claim, it is unpreserved, number one. Number two, as Judge Stein said, it has never been applied by this court outside of the Cyville line of cases, which are totally different from this situation. And moreover, there was no prejudice to the people. They like to say, well, if we had known by the time you filed your quorum nobis, we could have gotten counsel to explain what he did or what he didn't do. The fact is, they knew as early as 2006, they knew years before counsel died, that this claim was in the works, because Mr. Alvarez asked the appellate division to assign counsel for this claim. And when they denied that, he filed a 440 motion in the trial court and said, and also raised the claim of ineffectiveness of appellate counsel. The people responded by saying, well, you can't do that here, you've got to file quorum nobis, and the judge agreed, of course. But they were on notice way back then that this claim was in the works. If they thought there was any reason to speak to Mr. Brown, they had ample opportunity to speak to him. Now, in terms of prejudice, I know we talked about the question that, the standard, whether we're dealing with Strickland or meaningful representation. There is prejudice here. I can't say for sure that Mr. Alvarez would have gotten a sentence reduction in the appellate division, but the prejudice is he had an absolute right to have that court review the sentence. And when you're serving essentially life without parole, the fact that the law in New York gives you the absolute right to have a second bite of the apple, another court review that sentence and determine whether, you know what, we understand why Judge Snyder gave him that sentence, we understand why he was deserving of a very long time in prison, but we think a 19-year-old might mature someday, and we think that that's just too extreme. Let's knock it down to 25 to life. That wouldn't have been unreasonable for the appellate division to do. It would not have been that out of the ordinary. They do it all the time, as some of your honors know from your experiences on the appellate division. And in fact, he was denied his absolute right, Mr. Alvarez, to have that kind of review, that second chance review in the appellate division, and that is prejudicial to him. And all we're asking for now is for this case to be sent back for a de novo appeal so that he can raise that issue before the appellate division and say, look, I want to have a chance at parole someday.
Thank you, counsel.
Thank you.